The right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013. Chapter 8. Establishment of Land Acquisition, Rehabilitation and Resettlement Authority. Section 51. Establishment of Land Acquisition, Rehabilitation and Resettlement Authority. 1. The appropriate government shall, for the purpose of providing speedy disposal of disputes relating to land acquisition, compensation, rehabilitation and resettlement, establish, by notification, one or more authorities to be known as the Land Acquisition, Rehabilitation and Resettlement Authority to exercise jurisdiction, powers and authority conferred on it by or under this Act. 2. The appropriate government shall also specify in the notification referred to in subsection 1 the areas within which the authority may exercise jurisdiction for entertaining and deciding references made to it under section 64 or applications made by the applicant under second proviso to subsection 1 of section 64. Section 52. Composition of authority. 1. The authority shall consist of one person only, hereinafter referred to as the presiding officer, to be appointed, by notification, by the appropriate government. 2. Notwithstanding anything contained in subsection 1. The appropriate government may authorize the presiding officer of one authority to discharge also the functions of the presiding officer of another authority. Section 53. Qualifications for appointment as presiding officer. 1. A person shall not be qualified for appointment as the presiding officer of an authority unless he is or has been a district judge, or b. He is a qualified legal practitioner for not less than 7 years. 2. A presiding officer shall be appointed by the appropriate government in consultation with the Chief Justice of a High Court in whose jurisdiction the authority is proposed to be established. Section 54. Terms of office of presiding officer. The presiding officer of an authority shall hold office for a term of 3 years from the date on which he enters upon his office or until he attains the age of 65 years, whichever is earlier. Section 55. Staff of authority. 1. The appropriate government shall provide the authority with a registrar and such other officers and employees as that government may think fit. 2. The registrar and other officers and employees of an authority shall discharge their functions under the general superintendence of the presiding officer. 3. The salaries and allowances and other conditions of service of the registrar and other officers and employees of an authority shall be such as may be prescribed. Section 56. Salary and allowances and other terms and conditions of service of presiding officers. The salary and allowances payable to and the other terms and conditions of service including pension, gratuity and other retirement benefits of the presiding officer of an authority shall be such as may be prescribed, provided that neither the salary and allowances nor the other terms and conditions of service of the said presiding officers shall be varied to their disadvantage after appointment. Section 57. Filling up of vacancies, if, for any reason other than temporary absence, any vacancy occurs in the office of the presiding officer of an authority, then the appropriate government shall appoint another person in accordance with the provisions of this Act to fill the vacancy, and the proceedings may be continued before the authority from the stage at which the vacancy is filled. Section 58. Resignation and removal. 1. The presiding officer of an authority may, by notice in writing under his hand addressed to the appropriate government, resign his office, provided that the presiding officer shall, unless he is permitted by the appropriate government to relinquish his office sooner, continue to hold office until the expiry of 3 months from the date of receipt of such notice, or until a person duly appointed as his successor enters upon his office, or until the expiry of his term of office, whichever is earlier. 2. The presiding officer of an authority shall not be removed from his office except by an order made by the appropriate government on the ground of proven misbehavior or incapacity after inquiry in the case of the presiding officer of an authority made by a judge of a high court in which the presiding officer concerned has been informed of the charges against him and given a reasonable opportunity of being heard in respect of these charges. 3. The appropriate government may, by rules, regulate the procedure for the investigation of misbehavior or incapacity of the aforesaid presiding officer. Section 59. Orders constituting authority to be final and not to invalidate its proceedings. No order of the appropriate government appointing any person as the presiding officer of an authority shall be called in question in any manner, and no act or proceeding before an authority shall be called in question in any manner on the ground merely of any defect in the constitution of an authority. Section 60. Powers of authority and procedure before it. 1. The authority shall, for the purposes of its functions under this Act, shall have the same powers as are vested in a civil court under the Code of Civil Procedure 1908 in respect of the following matters, namely: a. Summoning and enforcing the attendance of any person and examining him on oath. b. Discovery and production of any document or other material object producible as evidence. c. Receiving evidence on affidavits. d. Requisitioning of any public record. e. Issuing commission for the examination of witnesses. f. Reviewing its decisions, directions and orders. g. Any other matter which may be prescribed. 2. The authority shall have original jurisdiction to adjudicate upon every reference made to it under Section 64. 3. The authority shall not be bound by the procedure laid down in the Code of Civil Procedure 1908 but shall be guided by the principles of natural justice and subject to the other provisions of this Act and of any rules made thereunder. The authority shall have the power to regulate its own procedure. 4. The authority shall, after receiving reference under Section 64 and after giving notice of such reference to all the parties concerned and after affording opportunity of hearing to all parties, dispose of such reference within a period of 6 months from the date of receipt of such reference and make an award accordingly. 5. The authority shall arrange to deliver copies of the award to the parties concerned within a period of 15 days from the date of such award. Section 61. Proceedings before authority to be judicial proceedings. All proceedings before the authority shall be deemed to be judicial proceedings within the meaning of Sections 193 and 228 of the Indian Penal Code, and the authority shall be deemed to be a civil court for the purposes of Sections 345 and 346 of the Code of Criminal Procedure, 1973. Section 62. Members and officers of authority to be public servants. The member and officers of the authority shall be deemed to be public servants within the meaning of Section 21 of the Indian Penal Code, 45 of 1860. Section 63. Jurisdiction of civil courts barred. No civil court other than High Court under Article 226 or Article 227 of the Constitution or the Supreme Court shall have jurisdiction to entertain any dispute relating to land acquisition in respect of which the collector or the authority is empowered by or under this Act, and no injunction shall be granted by any court in respect of any such matter. Section 64. Reference to authority. 1. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the authority, as the case may be, whether his objection be to the measurement of the land, the amount of the compensation, the person to whom it is payable, the rights of rehabilitation and resettlement under Chapters V and V or the apportionment of the compensation among the persons interested, provided that the collector shall, within a period of 30 days from the date of receipt of application, make a reference to the appropriate authority. Provided further that where the collector fails to make such reference within the period so specified, the applicant may apply to the authority, as the case may be, requesting it to direct the collector to make the reference to it within a period of 30 days. 2. The application shall state the grounds on which objection to the award is taken, provided that every such application shall be made. A person making it was present or represented before the collector at the time when he made his award, within 6 weeks from the date of the collector's award. b. In other cases, within 6 weeks of the receipt of the notice from the collector under Section 21, or within 6 months from the date of the collector's award, whichever period shall first expire. Provided further that the collector may entertain an application after the expiry of the said period, within a further period of 1 year, if he is satisfied that there was sufficient cause for not filing it within the period specified in the first proviso. Section 65. Collector's statement to authority. 1. In making the reference, the collector shall state for the information of the authority, in writing under his hand, a. The situation and extent of the land, with particulars of any trees, buildings or standing crops thereon. b. The names of the persons whom he has reason to think interested in such land. c. The amount awarded for damages and paid attended under Section 13, and the amount of compensation awarded under the provisions of this Act. d. The amount paid or deposited under any other provisions of this Act, and e. If the objection be to the amount of the compensation, the grounds on which the amount of compensation was determined. 2. The statement under subsection 1 shall be attached a schedule giving the particulars of the notices served upon, and of the statements in writing made or delivered by the persons interested respectively. Section 66. Service of notice by authority. The authority shall thereupon cause a notice specifying the day on which the authority will proceed to determine the objection, and directing their appearance before the authority on that day, to be served on the following persons, namely: A. The applicant. B. All persons interested in the objection, except such if any of them as have consented without protest to receive payment of the compensation awarded, and C. If the objection is in regard to the area of the land or to the amount of the compensation, the collector. Section 67. Restriction on scope of proceedings. The scope of the inquiry in every such proceeding shall be restricted to a consideration of the interest of the persons affected by the objection. Section 68. Proceeding to be in public. Every such proceeding shall take place in public, and all persons entitled to practice in any civil court in the state shall be entitled to appear, plead and act as the case may be in such proceeding. Section 69. Determination of award by authority. 1. In determining the amount of compensation to be awarded for land acquired including the rehabilitation and resettlement entitlements, the authority shall take into consideration whether the collector has followed the parameters set out under Section 26 to Section 30 in the provisions under Chapter 5 of this Act. 2. In addition to the market value of the land, as above provided, the authority shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of the publication of the preliminary notification under Section 11 in respect of such land to the date of the award of the collector or the date of taking possession of the land, whichever is earlier. Explanation. In computing the period referred to in this subsection, any period or periods during which the proceedings for the acquisition of the land were held up on account of any stay or injunction by the order of any court shall be excluded. 3. In addition to the market value of the land as above provided, the authority shall in every case award a solatium of 100% over the total compensation amount. Section 70. Form of award. 1. Every award under this chapter shall be in writing signed by the presiding officer of the authority, and shall specify the amount awarded under Clause 1 of Section 28. And also the amounts if any respectively awarded under each of the other clauses of the same subsection, together with the grounds of awarding each of the said amounts. 2. Every such award shall be deemed to be a decree in the statement of the grounds of every such award a judgment within the meaning of Clause 2, and Clause 9 of respectively of Section 2 of the Code of Civil Procedure, 1908. Section 71. Costs. 1. Every such award shall also state the amount of costs incurred in the proceeding under this chapter, and by what persons and in what proportions they are to be paid. 2. When the award of the collector is not upheld, the cost shall ordinarily be paid by the collector, unless the authority concerned is of the opinion that the claim of the applicant was so extravagant or that he was so negligent in putting his case before the collector that some deduction from his costs should be made that he should pay a part of the collector's costs. Section 72. Collector may be directed to pay interest on excess compensation, if the sum, which in the opinion of the authority concerned, the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation. The award of the authority concerned may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date on which he took possession of the land to the date of payment of such excess into authority, provided that the award of the authority concerned may also direct that where such excess or any part thereof is paid to the authority after the date or expiry of a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of such excess or part thereof which has not been paid into authority before the date of such expiry. Section 73. Redetermination of amount of compensation on the basis of the award of the authority. 1. Where in an award under this chapter, the authority concerned allows to the applicant any amount of compensation in excess of the amount awarded by the collector under Section 23. The persons interested in all the other land covered by the same preliminary notification under Section 11, and who are also aggrieved by the award of the collector may, notwithstanding that they had not made an application to the collector, by written application to the collector within 3 months from the date of the award of the authority concerned require that the amount of compensation payable to them may be redetermined on the basis of the amount of compensation awarded by the authority, provided that in computing the period of 3 months within which an application to the collector shall be made under this subsection, The day on which the award was pronounced and the time requisite for obtaining a copy of the award shall be excluded. 2. The collector shall, on receipt of an application under subsection 1, conduct an inquiry after giving notice to all the persons interested and giving them a reasonable opportunity of being heard, and make an award determining the amount of compensation payable to the applicants. 3. Any person who has not accepted the award under subsection the 2nd of May, by written application to the collector, require that the matter be referred by the collector for the determination of the authority concerned. Section 74. Appeal to High Court. 1. The requiring body or any person aggrieved by the award passed by an authority under Section 69 may file an appeal to the High Court within 60 days from the date of award, provided that the High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a further period not exceeding 60 days. 2. Every appeal referred to under subsection 1 shall be heard as expeditiously as possible and endeavor shall be made to dispose of such appeal within 6 months from the date on which the appeal is presented to the High Court. Explanation. For the purposes of this section, High Court means the High Court within the jurisdiction of which the land acquired or proposed to be acquired is situated. Chapter 9. Apportionment of Compensation. Section 75. Particulars of apportionment to be specified. When there are several persons interested, if such persons agree in the apportionment of the compensation, the particulars of such apportionment shall be specified in the award, and as between such persons the award shall be conclusive evidence of the correctness of the apportionment. Section 76. Dispute as to apportionment. When the amount of compensation has been settled, if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such disputes to the authority.